verified. Numbers don't lie, they testify. Thomas in the lab, books open, case law. Reading every line like a judge on the last call. Turned credit acceptance to a conquest. Took a contract apart, made him confess. Consumer finance, that's chess, not checkers. Built a blueprint, now we training whole sectors. From the payment plans to the charge-off sheets. He can map out the money like Manhattan streets. Understand risk, yield, real valuation. Break a deal down, show the hidden obligation. He don't chase clout, he chases precision. Every decimal in place like a surgeon's incision. Supreme elite, we got receipts stamped in the ledgers in the court transcripts. You see defeat, we see a breach. Thomas turned pressure and the long-term wins. Dark in the hook, but the numbers still glow. Empire built slow while the cash flow grows. Supreme elite, we got receipts. Every page proof that the
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume, war stories in the fine lines.
Yes, sir. Welcome.
You're rocking with the best.
We have another one today for you. Started a little late, my bad. And I mean, my bad, y'all. So today we're going to take a little around time. I haven't done these in a long time. We're going to do some case law review. We're going to do some in-court proceedings review. And we're going to see if this person actually can get out of this $30,000 debt, a $30,000 credit card debt. Now, me personally, a $30,000 line of credit, I mean, I would at least try to take that $30,000 and turn it into more money, generate receivables, generate income. So when I pay back my debt, I'm still making some money on the side off the top of it. TikTok, shout out to TikTok. We got TikTok in the building as well. So we're going to get into it. We're on the New Culture Empire. We on Facebook. We on YouTube. We on TikTok. We're about to be heading to Kick soon. That's where we get to the. It's gonna get real over there, and all the gloves come off on Kick and Twitch. We will be live over there soon. If you haven't done already, please join the Patreon, the New Culture Empire at the Patreon. We got a lot more tiers. We still have that credit repair class. If you was interested in viewing it, the video is going to be on TikTok. It was taught by a litigator, a professional. It will actually help you and get in depth in the rules and the laws and the regulations, all the multiple claims you can bring for my consumer people. But without further ado, let's see what's going on here.
And we are on the record for the 21st Judicial District, Division 10, involving U.S. Bank National Association versus Adam Dietrich, case number 25 CV 3023223, excuse me. We're here for trial of this matter today.
Trial. This is trial. This ain't back and forth motion stage. We're beyond the motion stage. We're in trial now. In court proceedings.
We'll let plaintiff's counsel commence with any preliminary issues that we need to address.
Your Honor, Alex Adams for the plaintiff.
Thank you, Mr. Adams. Are there any preliminary issues that you need to address before we start with testimony?
I do not believe there are any preliminary issues, no.
Hey, y'all, why do these lawyers always come online? Like, look at the witness, too. They always got these cheap-ass headphones. Them old, remember those old Sony headphones that had the little wire, the little metal at the top? Why do these lawyers always come online with these old-ass cheap headphones? I never got that.
All right. And who appears for defendant?
So Adam Dietrich.
Thank you, Mr. Dietrich. And are you here representing yourself today?
Yes, Your Honor.
First red flag. First red flag.
And do you have any preliminary matters that you'd like the court to address?
No.
All right, Mr. Adams, I'll let you go ahead and proceed to call your first witness.
Okay, this is the important part now. This witness right here, he is the one that's going to be pretty much testifying to the numbers, the account, the things like that. See, under the rules, the business rules, and the rules of evidence, this is where the business records and the exception to the hearsay rule comes into play. See, this is where this pro se litigant, we're going to see if he actually knows what he's talking about and actually analyze the documents that they file. Because remember, over here at the New Culture Empire, anything that they file on the record is actually our evidence against them. So let's see where this goes.
Thank you. The plaintiff, U.S. Bank National Association, would like to come.
I'm sorry. I get into the habit of just like jumping into hearing mode. If either of you would like to present opening remarks, you are more than welcome to.
Judge, get it together now. Get it together.
Jump right in, and my apologies. If you'd like to present some opening remarks, I'm happy to hear them.
Sure, I can
Thanks.
have some quick remarks. So this is a simple debt collection action to recover an unpaid balance on 2 credit accounts. The plaintiff, U.S.
Adam, okay.
Bank National Association, will show that it is entitled to a judgment for breach of contract on both accounts.
So their claim is a breach of contract. When they sue you in court, they're going to sue you on a breach of contract. What's the breach of contract? Everybody in the world knows why you're being sued in court. All this, I don't know why I'm even here. No, the breach of contract is non-payment. That's what they are alleging.
The claims are brought by the plaintiff to enforce the terms of the card member agreements, and the defendant has breached those terms by failing to make payment.
I object, Your Honor.
That's an opening statement. He's not introducing anything into the record. You can't object to an opening statement, as I believe, unless they're just getting into the case.
This is hearsay.
Oh, sir,
By the plaintiff.
Mr. Dietrich, these are opening statements.
God damn it. God damn it already. Already. Already.
The rules of evidence don't apply to opening statements.
What did I just say? The witness there under the rules of evidence. I'm telling you, in court proceedings is the key here.
He's simply telling me what he expects the evidence to be,
Okay.
and you'll have the opportunity to do the same thing. So objection is overruled and you may proceed, Mr. Adams.
Come on, boy.
Thank you. Consequently, the defendant is liable to the plaintiff for the principal amount of $30,002.94.
Now, let me ask you a question. Why couldn't they just keep it around up at 30,000? Why did they have to get to the $2.94 being petty? Just make it an even number.
The evidence presented will reflect that there is no dispute to the validity of the contracts, the stated accounts, and the amount of damages. And the defendant will not be able to show evidence to refute the plaintiff's claims or sets.
Hold on.
The evidence presented will reflect that there is no dispute to the validity of the contracts.
So he's saying what they're relying on right there in that moment, what they're saying is you can't dispute the validity of the debt. Okay? The validity of the debt. Basically, what he's saying is you already got the line of credit, you already swiped, you already used it. You can't dispute that. Now, that wouldn't be a point of contention for me. I wouldn't dispute the debt if I know I used the card anyway. I would be more focused on that $30,002.94. It's part of the ledger, the audit report that I have. That's where I'll be focusing on those numbers right there. Remember, I'm a numbers guy. I'll be focusing on those numbers.
The stated accounts and the amount of damages. And the defendant will not be able to show evidence to refute the plaintiff's claims.
So it's a stated account, basically in court. That's an account stated. Pretty much, they got the balance of the account, etc., etc. So basically, with their whole premise is, you took out the agreement. You know you took out the agreement. You didn't pay. Therefore, we win. That's what the plaintiffs. That's going to be all of it universally. That's all they're coming with.
The plaintiff will prove by preponderance the evidence that the defendant has damaged the plaintiff in the amount of $30,000 or $30,002.94.
Now there, 30,000. Yeah, you took my son. Yeah, why had the 294? Simple, just 30,000. Yeah, go ahead and correct yourself.
Excuse me. And the plaintiff is entitled to a judgment. Thank you.
All right, thank you very much. As I was previously explaining to you, Mr. Dietrich, you now have the opportunity to also make an opening statement, or you can wait and do so at the beginning of your case in chief. Do you want to present one now, or do you want to wait until after the plaintiffs have presented their evidence and give one then?
I would actually wait for them to present their evidence, and then I would follow up all the way behind them so I can get their evidence on the record.
Yes, Your Honor, I can give us a brief statement now.
I will be happy to hear from you. Please go ahead.
As implied surety, beneficiary, and subrogee, the plaintiff has refused.
Hold on. What did I just hear? Hold on.
Surety, beneficiary, I can give us a brief statement now.
I will be happy to hear from you. Please go ahead.
As implied surety, beneficiary, and subrogee.
I already knew it. Sovereign citizen, implied beneficiary, surety, and subrogee that has no legal basis in law and fact in any courtroom. Anybody that's listening right now, that is not a legal defense. It has nothing to do with the rules, procedure, case law. They're getting that subrogation. It's that old Supreme Court with the right of subrogation, right, 1800s. Ladies and gentlemen, that is not going to get you the proper defense or the outcomes you desire in court by stating that.
The plaintiff has refused to provide the 4 elements of a valid contract, thus never validating or verifying the debt. They have refused to provide the full accounting of the alleged debt. The witness does not have any firsthand perfected knowledge of the material facts in this case. Bank statements are hearsay and thus not admissible.
Okay. I see where he's going with it, even though he's reading from a script. I see where he's going with it. The witness, I guess he's saying that's hearsay. And the rules of evidence, it's not hearsay unless the witness can lay the foundation, meaning how do you use these records in your ordinary course of business? How do you incorporate these records if you got it from a third party? And what's the underlying foundation, meaning how did you get to these numbers that you claim they owe? Most of the time, they're just going to read from a screen. I totally expect this witness with the white shirt to read from the screen, just read the numbers off. He's not going to provide the source of the numbers, how they did the calculations to come to it, any equations that they use to come to it. If they use a proprietary system that does it for them, they're not going to explain how that system works. So he has some pretty decent arguments, but the beneficiary, it's like he's mixing somewhat legitimate legal arguments with online theories. So it's already convoluting his claim.
Thank you. Do U.S. Bank National Association's records reflect that the defendant defaulted?
Yes.
And referring to both accounts, why are these accounts in default?
For a defendant's failure to make the minimum.
No. Objection, Your Honor. Leading the witness. Why are these counts in default? No, the proper question should have been, as of right now, this date, are these counts in default? Yes. What are the terms of the reasons, that an account will ordinarily be in default? By non-payment. Why is the account? I would have objected. Leading the witness.
Payment.
And referring to both accounts, why are these accounts in default?
Right there, you're leading the witness.
For defendant's failure to make the minimum payment.
And this is the problem with pro se litigants in court. This is the problem. When they object because they don't like what they're hearing. They don't like what's being said. When you object, you got to have a legal reason why you're objecting. It has to be a legal basis for an objection in court. This ain't just the documents filing motions back and forth. I know a lot of these social media gurus, teachers online. I know they got, oh, here, documents, file a motion, file a response. I got you here. But what happens when your client has to sit in open court? Now, this is where the real teaching comes in at.
Thank you. And as a condition of the continuous default on the accounts, did the entire balance become due and owing on both accounts?
Yes.
Thank you very much. No more questions, Your Honor.
And what did I tell you? What did I tell you? What did I tell you? That's all they're going to ask them. How did you arrive to these numbers? What systems did you use to incorporate these? None of that. Very baseline, very generic, very just straight to the point. No. Let's play this line of question over again. Watch this line of question.
Thank you. Do U.S. Bank...
Give one in.
Refused to hearsay.
Watch this.
Thank you. And as a condition of the continuous default on the...
For defendant's failure to make the minimum payment.
Hold on.
Thank you. Do U.S.
Hearsay, and thus...
All right. We got to get right here. Watch this.
Thank you. Do U.S. Bank National Association's records reflect that the defendant defaulted?
Yes.
And referring to both accounts, why are these accounts in default?
For defendant's failure to make the minimum payment.
You see that? Very baseline, very vague, very surface level, just an inch. Just that's all they little, just little neat questions.
Thank you. And as a condition of the continuous default on the accounts, did the entire balance become due and owing on both accounts?
Yes.
Thank you very much. No more questions, Your Honor.
And that's it. Now, the defendant, I want to sit back and see, because that was a very, they didn't really, just the counts in default. That's it. Oh, I want to see what he has to say.
All right. Thank you very much. Mr. Dietrich, you have the opportunity to cross-examine now.
Yeah, cross-examination. Let's go.
If you would like to. Would you like to ask questions of Mr. Gifford?
Yes, Your Honor.
Go ahead.
Mr. Is it Gifford?
Yes.
Okay. So as a reminder, you are under oath.
Come on, just get to it.
Penalty of perjury if you do not tell the truth, the whole truth, and nothing but the truth
Oh
regarding your first-hand perfected knowledge of this material facts of this case. Do you know the definition of first-hand perfected knowledge?
Irrelevant question. An irrelevant question. First-hand perfected, first-hand irrelevant. See, pro se litigants, this is what I mean by you're wasting time. This means nothing.
I'm sorry, did you have a question about the account or?
Right. That has nothing to do with nothing.
He
I'm
did
asking,
ask.
do you know the definition of first-hand perfected knowledge?
That's not getting to you where you want to go in the case, though. It's a nothing burger. And pro se litigants throughout these space, they waste so much time on technical nothing burger arguments. Come on.
I'm just not sure what the question's relating to for this account.
Sir, you do need to answer the question.
No, I don't have the definition on hand.
You do
Just say that.
not know the definition of first-hand perfected knowledge? Okay. Is looking at a computer screen first-hand perfected knowledge?
That's a good question. That's a good question. But looking at but it's a good question, but he's wording it wrong. And we know he's looking at a computer screen. You're supposed to ask him questions that is going to attack his firsthand knowledge. How did you derive to these numbers? what factors went in calculating the numbers. What systems did you use? How do you incorporate this in your, or like those are like,
I don't know.
and the reason why is because many people get their arguments from what other people say on social media. Your arguments have to be in line with the court rules. This is the rules of evidence stage. So you have to be familiar and knowledgeable and have the proper interpretation of your state's rules of evidence. I know a lot of people stay away from the rules of procedures because it's too long to read, but that doesn't take away the fact that you have to understand these things when you're open court. Now, he's asking a good question. I see where he's trying to go with it, but his question has to align with the rules of procedures. So if the rules of procedures say this is not it, this is not it, it has to have this, has this, my questions will be in line that will prove that under the rules that he doesn't have firsthand knowledge. Not because my questioning says he doesn't have firsthand knowledge.
Have you ever been employed with U.S. Bank?
Yes, currently employed with U.S. Bank.
Did you see a certified copy of the original wet ink signed contract between the plaintiff and the defendant?
There you go, right there. This is one of the main things I talk about. You start off with a little bit of legal, but then as soon as you run out of legal stamina, you go right back to what you know and what you're used to. Wet ink signature. When there's no requirement to produce you or pull up a wet ink signature because everything is electronically stored now. And there is no signature on a credit card contract. The agreement is mailed in the mail to you, and you consent to the terms of the contract as soon as you swipe it. You have to return the card in order for, that's your way of saying, now I don't like the charge, now something ain't right here. But many people will never return the card. They're going to use the card first, then find issues with the card later.
I'm sorry, can you say that again?
Did you ever see a certified copy of the original wet ink signed contract between the plaintiff and the defendant?
We don't have written contracts, it's card member agreements.
What did I just say? There is none. There's nothing that you sign. See?
So is that a yes or no? Did you see a wet ink signature contract between the plaintiff and the defendant?
No.
No. Are you a certified public accountant?
No.
No.
And he doesn't have to be.
What are the general accounting rules of credit card accounts?
You don't even know it.
I'm not an.
And they're not called accounting rules for credit card accounts. They don't differentiate between a credit card, mortgage, or auto on their financial statements of position. See, this is right up my alley now because I read balance sheets. They don't differentiate.
Accountant, I can't answer that.
Right. Thank you.
And remember, the court is only looking at a complaint was filed for non-payment. The credit card agreement was attached. The account stated was attached. The account is in the red, default. That's what the court is looking at. He has to present compelling evidence to prove the illegitimacy of the debt or the incorrect amounts claimed. So all these, do you know the accounting terms for this and the accounting for this, the accounting for that? It's not getting to the legal lens. Remember, 5 lenses of the contract. You got your corporate finance lens, you got your regulatory lens, you got your investor lens, you got your legal lens, you got your consumer lens. 5 different ways of how the contract is being viewed.
What is a T ledger?
None of that matters.
I'm sorry, can you say it again?
What is a T ledger?
What is a T ledger? God. The transaction ledger has nothing to do unless you're using it to prove under the court rules why they can't collect on the debt, why the amounts are inaccurate, or why he doesn't have firsthand knowledge. Remember, court is not about you proving your evidence and how you see it. And oh, I got it right here. Court is 98% rules and procedure. The other 2% are the facts of your case. If you don't understand it now, you're going to learn that the hard way in court.
A T ledger. I'm assuming that's something with accounting again. I'm not an accountant.
Okay, so did you look at both sides of the ledger? I'm assuming that.
Sorry, y'all.
We don't have a ledger.
Okay, so did you look at both sides of the ledger?
This is what I mean about accounting in this space, ladies and gentlemen. 98% of people who talk accounting, they don't understand accounting. Even the ones who really think they understand accounting, they don't understand accounting the way they think they understand accounting. There is no ledger when you're dealing with financial statements of position. There's no both sides of the ledger. Accounting is way more complex than just a debit and credit. That's that stripped down, generalized, watered down version that social media uses. Accounting has so many different components to it. What he's talking about, what he's trying to infer, he is talking about the accounting for the receivable. And then those receivables have to be measured. Then they have to be netted. See, he should have been talking about the ACL, the CECL. He's supposed to have been talking about all the netting that has to go on the balance sheets before they can present the account. And then you got to toe the line with accounting, because some of the statements of position, when you deal with accounting, is for presentation only, not really attacking the underlying debt. So you have to use their presentations and how they're supposed to do things on the back end to prove it and tie it back to your case, because once they do the adjustments in the netting, it actually affects the balance due that they're claiming. Remember, it's one balance that they bring to court and saying you owe. It's a totally different balance on their balance sheet. Obviously, he doesn't even know that part of the system exists.
I'm assuming that.
We don't have a ledger that I review for credit card statements.
They don't.
Okay. What is the meaning of full accounting of an account?
Oh, God.
Give me 1 second.
None of that.
You need to Google it.
Yeah. I don't. I mean, full accounting. I don't know what that's in relation to.
He is okay. So yeah, if you're lost right now, why he doesn't understand what he's talking about, because the guy that's asking him questions, he's talking about his very limited, minute understanding of the accounting system. This guy in the white, the ones who's the witness for the bank, he's talking about the borrower's specific account. So the one who's crossing right now, he is supposed to narrow his accounting verbiage down to his specific account instead of trying to ask them general accounting knowledge, which it has no applicability to his case. And the lawyer, people are wondering, why isn't he objecting? Because he doesn't need to object unless he starts to go fully off the rails. The more he opens his mouth and talk, he's actually proving U.S. Bank's case for him. That's why he's letting them talk.
You don't know?
No.
No, okay. Did you know that the plaintiff was requested to provide a full accounting and that they have refused to provide it?
That is supposed to be on your closing. That has nothing to do with the witness. Timing of your arguments, timing of your statements.
If you're talking about the validation of debt, that was satisfied.
No, provide a full accounting of the account. And they have failed to provide it. Are you aware of that?
I'm not aware of any such request.
Do you know what concealment is? It's when you refuse to provide exploratory evidence that would exonerate the other party and that the concealment is fraud. Have you or the plaintiff concealed the... Do you know what concealment is? It's when you refuse to provide exploratory evidence that would...
Exculpatory evidence, not exploratory, exculpatory. They already said they provided you with a validation of debt. The problem with people in their validation of debts in these spaces, they're asking for validation of debts based on what they heard, what they saw. They don't understand that a validation of debt, a debt validation is governed under the statutes. They only have to provide you what the statute requires. They're going to provide you with the name of the creditor, the original creditor, the identity, all the little information that you probably already got at closing. That's all they're going to do to validate the debt. When you're thinking about a debt validation, you're thinking beyond what they're seeing and what the statute allows. The statute basically, is this person's account? Is this their information? Is this the amount that they owe? Is this the name of the servicer? Is this the name of the creditor? That's all you're going to get from them. Y'all want to use debt validation letters to tie in your social media theories on how the transaction went. And this is why y'all think they're concealing or it's fraud. They're not concealing anything or committing fraud against you because they only have to answer to the statute. But if you think statutes don't apply to you as the living, breathing flesh and man, you're going to run in conflict with your beliefs and the statutes every time. But the statutes and how things work are going to defeat your beliefs every time. And a lot of y'all should already know that because you've been getting your head smacked through the white meat for the past several years.
Exonerate the other party and that the concealment is fraud. Have you...
Now, if you use the word fraud, you have to satisfy the 5 elements of fraud under the heightened pleading standards under Rule 9B in every state's equivalent. The who, what, when, where, how. The problem is many people would claim fraud, but they don't understand under the statutory elements or the court rules of evidence how, number one, the court is actually raising the standards of your pleading just by putting the FRAUD in your complaint. Now the threshold of you passing the court sufficiency test has went through the roof. If you could have just left the word fraud out and used the inconsistencies to show the inconsistencies within their claim against you, you will have a better time of passing the threshold and moving your case from possible to possible to plausible that they committed the acts that you're requesting. But no, this space tells you fraud, and they think just because you say fraud, everybody's going to run and hide under the bed. And that's just not going to happen.
You or the plaintiff concealed the full accounting?
It's 5 elements under the court rules of fraud. It's not 7 elements. If you believe it's 7 elements, maybe you're reading from a different document or a different court rules that's pretty much universal. It's 5 elements. It's the who, what, when, where, how. Those are the 5 main elements that they look for.
When asked for?
No.
Do you know what collateral securities are?
I do not.
So were there any evidence of collateral securities associated with these accounts?
It's unsecured debt, so I don't think there would be collateral involved.
And he's absolutely right. It's an unsecured debt, number one. And number two, collateral securities, when it gets into court, this is the problem. Everybody wants to use securitization. They created securities from it and try to bring that into the courtroom. Very few people, and this is why I tell you, this is one of the reasons why, this is one of the main reasons why I tell people to get and set you. Because very few people know how to take that side of the world, that side of the secondary market, and apply it to a consumer transaction. I am one of the very few people who knows how to merge all 5 lenses of the contract into a single complaint. And y'all already know that. This is a very tedious, it's a very, very, very tricky thing to pull off. And it's not easy just to pull off in every general case. It has to be structured, has to be, it's tedious work that goes into it. One false argument, all the rest of your building blocks fall.
Do you know if there are collateral securities associated with this account?
Again, it's credit card debt. It's unsecured.
Okay, you're a witness. I'm just asking questions.
But the questions that you're asking in open court, none of that has any legal validity as to their right to collect the debt. I don't say the 5 lenses for just to talk out the side of my neck. The court is not looking at the secondary market. They're not looking at securitization. They're not looking at if securities has been issued against your obligation to pay. They're not saying that. In order for them to look down that hole that you want to look down, you have to present compelling evidence, and then you have to introduce it in a strict proper way. If you think you're just going to attach an SEC filing to your complaint and think that's enough, many people has tried that over the last 20 years, and all of them has laws because they think that all they got to do is attach it and the judge is going to figure it out for them.
Remember, you're under oath. Do you have any firsthand perfected knowledge that the defendant contracted with the plaintiff?
Objection, Your Honor.
Basis of
Asked
your
and answered.
objection? Sustained.
Yeah, I knew it was coming because it just has, y'all, that his line of questioning has nothing to do. Remember, what you see, what you uncovered through your quote unquote research, when it gets to court, y'all think you could just take your findings and research and just slap it in the court's face. There's a certain way these claims have to be argued in court. You can't just throw, hey, my collateral security has been issued again. No, you're going to lose. You have to say it without saying it, if that makes sense.
Sorry, what was that? The screen.
There was an objection that you have already asked that question, and indeed you did ask him about firsthand. State your question again.
No, I was asking if he has any firsthand perfected knowledge
Of
that the defendant contracted with the plaintiff.
Horrible question. You've already swiped the card. I'm pretty sure you made payments on the card. When you swipe the card, you have consented to the, y'all see what I'm saying? You get so much farther by just recognizing that you got the debt. You got the credit card. Don't use it. I didn't get it. No, wasn't. You got a contract with me. They know you got a contract with them. They wouldn't be bringing you into court if they didn't. That's what I mean. Wasting time on these frivolous arguments instead of getting to the meat and potatoes of the claims. This is a trial. The U.S. Bank is bringing the witness on to testify to the account, the records they probably submitted that throughout this course of this litigation. This is the trial. The only thing he's supposed to be attacking is the validity of the records, the accuracy of the amounts due, because this goes into the evidence that they're using at trial. When you attack the foundation of the elements and the evidence that they're going to use against you, everything else falls to the wayside on its own. You have to put your energy in places where it matters the most.
So previously you had asked about his knowledge of the term firsthand perfected knowledge. So I'm going to overrule the objection for asked and answered. Mr. Adams, do you have any other basis for your objection?
Judge, that was a very good observation. That's how court gets down to words. That's how nuancey court is right there. She overruled U.S. Bank's objection because he asked, did you know about the term? Now he's asking him a different question. But that one word, do you understand the term, was got the U.S. Bank's objection overruled. That's how nuancey court is when you're in open court. Ladies and gentlemen, I know this is a space where you just document push back and forth in court. It's a totally different ball game when you get inside of court, inside the courtroom, in open court. I spent 22 and a half years inside courts. I know what I'm talking about, state and federal.
No, Your Honor.
Go ahead and answer.
Sorry, can you state the question one more time now?
Yeah, no problem. Do you have any firsthand perfected knowledge that the defendant contracted with the plaintiff?
Firsthand knowledge, no.
No, okay.
But see, the question would have been so much better if he would have took the firsthand knowledge and applied it to how's it incorporated in your business record? How did you get to the numbers? How did you get to the judgment figures? Do you know the systems that instead of saying, do you know if you contract with me? Because really, it's not his job to know if he contracted with you. It's not his job. It doesn't really prove anything. See, we think every little question that he says no, that, oh, he's winning, he's doing a good job. I'm looking at it from a legal standpoint, from what the judge is looking at. Because we're at this stage of the proceeding. This is trial. Now, this is at the stage where they have to prove the balance due. I'm telling you, stop the foreclosure dead in its tracks 2 times in a row. They can't get around the numbers. They can't get around the numbers. I'm telling you, on multiple occasions, I done beat these people. We done beat these people. The Supreme Elite team done beat these people off the numbers. Not just me. Members in my group too. Been spanking these corporations all 2026.
Do you have any firsthand perfected knowledge that the defendant financially harmed the plaintiff?
Firsthand knowledge, no.
No.
Decent question, but I would have tied it in to the accurate amounts due, balance due, and all, things like that.
See, therefore, Your Honor, I move that this witness be ruled incompetent and all their testimony be stricken from the record.
Do you wish to respond, Mr. Adams?
No.
Yes, this witness has already been qualified as an operations manager, a custodian of records.
I would object to that.
Hold on, let him finish, and then you can present your response. Go ahead.
See, as pro se, you are supposed to know that in court. Let him finish. The judge say he can finish. Get you finished, then you respond.
Based on this witness's responsibilities with U.S. Bank, national associations,
and I knew he was going there based on his responsibilities. Now I knew he was going there because I already talked about it. It's not his job to know all this extra stuff. He's going to narrow the scope into his job. I already know where the other side's going with it because I would have went the same way. He's going to, Your Honor, it is not his job to understand these incomprehensible accounting terms. His job is to boom, 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 boom. So watch what the lawyer says next.
Familiarity with the business records and the record keeping. This witness is a U.S. Bank National Association.
Present your response. Go ahead.
Watch this.
Based on this witness's responsibilities with U.S. Bank National Associations and familiarity with the business records and the record keeping, this witness is a qualified witness.
What'd I tell you?
You're rocking with the best.
What'd I tell you? We're going to narrow the scope. Record keepings right there. It's going to narrow the scope. Bring them right back into the... I'm telling you.
Okay. So, Mr. Dietrich, what you're trying to get to when you're talking about this firsthand knowledge is an issue that would be relevant if we were dealing with the capacity of hearsay.
She just said the same thing. She said the same thing. It would have, if he actually would have attacked the business records and the exception to the hearsay rule under that state's court rules. It would have. See, he was more close to what he thought, but in these spaces in court, you could be so close but so far away at the same time because the margin of error is very small in court. So he was making the undertone of his argument was correct, but he wasn't arguing it correctly. And that is inches, the difference. You could be having the proper tone, the proper substance, but if you argue it correctly in court, it's just like you never made the correct argument at all. That's how it is in open court. That nobody's sitting there with the copies of the rules of procedure and citing them word by word, analyzing it in open court. No. It's a different arena and arguments when you're in open court. You can file a motion all day and put it on the record. When it gets time to argue the motion, that's not the time for you to recite the motion that you filed into the record. Now you have to argue the motion. That's a big thing in these spaces that nobody talks about. Open court. How to move in court. When they talk court in these spaces, it's just documents, filings, motions, back and forth. But inside of open court makes the difference. You can have an ironclad motion on the record, but if you argue it wrong or if your words in court don't match what's being filed, you may lose that case.
But because these records fall within the exception to the hearsay requirement, his firsthand knowledge is covered by that business records exception. So he has.
What did I say? The exception to the hearsay rule. He was supposed to attack the exception to the hearsay rule. See, he didn't lay. See, when you don't attack it, it's going to be the exception. You have to attack the exception to the hearsay rule. Attack his actual knowledge. How do you know? He didn't ask him nothing about, well, how these records are integrated? What's the modes and mechanism on how you integrate these records? How did you derive to these figures? See, all of that plays into it. He was in the arena, but he wasn't in the ring with his arguments in this line of questioning. And this is why the judge is saying what she's saying.
Testified that he has firsthand knowledge of how U.S. Bank conducts its ordinary course of business.
You always hear me say that word. They're always going to use that baseline word, the ordinary course of business. They're going to say that shit all day, every day.
How U.S. Bank conducts its ordinary course of business, how they send their statements, how they keep track of the bills, how they keep track of the payments that are made, how they keep track of the requests for payments that come in through their electronic systems. That renders him competent as a witness as to the things that Mr. Adams presented him as a witness on. So I'm going to deny your motion to strike him as a witness. You may proceed with your cross-examination.
Of course. Want to know why? Because he didn't make the wrong arguments. But let me tell you this. I'm going to give you the flip side of the nuance of court. When you are sitting in open court and this business records and this stuff comes into play, if your account is in default, the likelihood of the judge not allowing those records to be admitted is slim to none. I don't care what teacher you have. See, we talking open court now. We're not talking just back and forth with emotions. We talking open court. Oh, hold on. 1 second. Hold on. All right.
Is there any evidence that I'm the debtor?
This is when you ran out of gas, legal stamina, and now you just gotta shoot something out there and hope something sticks.
Yes, that would be the card member agreements and the card member statements that you received at your address.
And again, just for the record, I've requested evidence of a contract, and there has been none sent to me.
Because he just said it. It's a card holder agreement. It's a card holder agreement. He already lost the case when he didn't challenge the records and the evidence that was being submitted ahead of trial. He didn't file a motion to challenge it and contest. So on the same day, they could have had a hearing on his challenges contesting the record submitted. So he's already lost because I know he didn't do any legal challenges to it. So he's already lost there.
I have no further questions, Your Honor.
Objection, Your Honor. The contracts have been admitted as Exhibits 1 and Exhibit 5.
What did I just say? They've been admitted as Exhibit 1s and Exhibit 5s. He didn't challenge those as soon as they filed it on the record. He was supposed to challenge it way before this day. He's already late. Remember, if you don't raise it, you waive it. Can't save it.
Okay,
Would
so
object to that.
we're gonna back up a hot minute. The statement that Mr. Dietrich made wasn't a question, and so it was not properly submitted to this witness. And I'm going to sustain an objection on that ground. Mr. Dietrich will have the opportunity to present his own testimony, and if he wishes to present that statement at that time, then I can consider it at that time. But it's not a proper commentary on this witness's testimony at this time in the proceeding.
So basically, the reason why she sustained the objection, because instead of questioning the witness, he was pretty much just testifying. Hey, you know, I sent this and this, and they never responded. That's not the proper questioning for a witness in court.
Do you have any redirect questions you want to ask, Mr. Adams?
Yes.
Go ahead.
Mr. Gifford, right, based on the card member terms and agreements for both of these accounts, you stated that use is acceptance of the agreement.
What did I just say? In every cardholder agreement, when you use the account, you have agreed to the terms. All right, what's up, y'all? TikTok, you say he should ask questions about his job duties to lay a foundation for lack of personal knowledge. Well, they've already established his job duties, so I think that would have did. Magical wet ink. Oh my God. He said you have two options, but Soft says got to make it fairy tales and rainbows. He's questioning the call center operator by the looks of it. Kind of is good point, Thomas. He's using words wrong for real. Can't fault him for trying though. Nah, I wouldn't fault him. It's frustrating because I see where he was going. I know what he's trying to get to, and he actually could have had this witness rattled with the line of questioning. But the lack of understanding of court kind of is what it's, yeah, that's kind of what is the deciding factor here.
Did the defendant use these credit accounts?
Yes, both accounts.
What did I say? I've been telling y'all this for 3 years. They're going to go in court and say, regardless of anything he or she's saying, they got the credit card, they swiped the account, they used the account, they made payments on the account, thereby consenting to the terms of the account. And that is a hard thing to defeat. This is why we don't get into that. Because you can't defeat it, y'all. Social media, you got to stop acting like you can just wipe away the fact that you signed up for the card, you used the card, you benefited for the card, and then when it comes to pay, you never had the card. But you got to move away from that and start getting to, hey, I'm not challenging that I owe you. No, that's cool. You sure I owe you the correct amounts, though? You sure those numbers add up? Because that's a more strong and powerful argument, because without the accurate amounts due, that precludes summary judgment on the amounts that they claim. And if you understand accounting, if the first set of numbers are off, you can't supplement them and add a new set of numbers off. without reconciling the difference between the first set of numbers and the new set of numbers. Accounting is like a web. See how easy it is to break through a web, spider's web. If one number is off, all of the numbers are off.
And again, earlier you stated that default on these accounts could be by failing to make payment. Is that correct?
That's correct.
He was supposed to object in the beginning for leading the witness. Because that's not what he did. You just pulled a fast one, U.S. Bank. You let him. Now he's framing it like that's what the witness said after you let him. See? Proceed. Adams. Come on, man.
Did the defendant fail to make payments on these accounts?
Yes, for both accounts.
Okay, social media. How do you get around that? Failure to make pay. How do you get around that? What's your argument around your failure to pay under the agreement? Because now you have a binding contract which is enforceable at law. How do you get around not paying? And teachers, this is what I tell about you social media teachers. Stop telling people that you can get around the fact that you didn't pay. Stop telling them that. Stop telling them that, oh no, don't worry about not paying. Nah, they got to prove you got the contract. Where's the original contract? Stop it. You're doing more harm than good. And it's a bad faith argument. Nobody will ever be held accountable to pay a debt that they know from a legal standpoint that they never even contracted for, because it would be so easy to prove what you were doing on the day that contract was originated. If you never, this is what I'm saying. The arguments, wet ink signature proof, basically what you're saying is I'm a victim of identity theft. I never even filled out the application with y'all. That's what you're saying, because that's the only way. And if you were really the one that never filled out the application, you will be able to support that and substantiate that. You know how it is when you're telling the truth. You ain't got to think about it. You know if you didn't. You'll have all the evidence, witnesses to show, especially the date when the origination took place. How did I originate? I was here this time with this bit with this. Come on now. So let's stop being disingenuous and let's start making good faith arguments.
And is the defendant in default?
Yes.
Thank you. No more questions.
And that's all the court needs.
Thank you very much for your testimony, Mr. Gifford. Mr. Adams, do you have any other witnesses?
No more witnesses.
That's all you needed.
Mr. Dietrich, do you have witnesses you would like to present?
No, Your Honor, I do not.
Do you wish to present testimony on your own behalf?
No, Your Honor.
No. Ah, shit.
I would ask.
Go ahead.
I've tried to.
So why wouldn't you want to present testimony on your own behalf? You want to know why he didn't present testimony on his own behalf? Because he knows deep down inside, he couldn't refute anything that was just said. He knows he got the credit card. He knows he made payment on it once upon a time. He knows he stopped making payments. He knows he went into default, and he knows he has no argument for that. Just like anybody else that's in default, you have no argument for your default.
Explain that there's no evidence of a contract yet, as of yet, which I've asked for. I've sent verification and letters. They were ignored. Also, throughout the filings in the courts.
Mr. Dietrich, what you're presenting, what I think are closing remarks, but you're addressing some things that are not yet in evidence. Are you sure you don't want to provide testimony on your own behalf?
I try to tell him, I don't know why he did. What I just say? You might as well. So I was just saying,
Um,
yes, you might as well.
I can provide a testimony.
Yeah. You ain't got
Raise your
nothing
right
else.
hand.
You have nothing else to lose.
Do you solemnly swear that the testimony you provide before this court will be the truth, the whole truth, and nothing but the truth, subject to the penalty of perjury?
What's up, y'all? Let's get these likes up. Let's get these likes up. Share the stream. Share the live. TikTok and YouTube. Let's get these likes up. Share the screen. Hit that screen. Hit the like. Share the screen. Let's get it.
Yes, Your Honor.
When you're testifying on your own behalf, you don't have to ask yourself questions. You can just
okay.
tell me the important factors you think I should consider. Go
Okay.
ahead.
Can I?
Okay, this is when you call the courts helping the pro se litigant. She just helped them. This is why she said, you sure you don't want to have testimony? Because basically that's what he said no, he didn't want in the beginning, but then he proceeded to testify. So she was helping him out like, nah, motherfucker, you really want to testify. Go ahead. I'm going to provide the leeway for you. See, these little subtle ways that they'll help you in court.
I recuse that. I would rather not.
You never have to testify.
Okay,
You can
thank
if you want to, but you're not required to do so. If there are facts that you know that haven't been presented yet that you think are important for me to consider, this would be your chance to tell me about those facts.
Yeah.
She just threw you another alley-oop. Read between the lines. God, this is why these things get so frustrating when I see this stuff throughout these spaces. It gets so frustrating.
Yes,
They
there are
need
some
to be things that you have firsthand knowledge of. You've talked a lot about firsthand knowledge today. So if there are things you have firsthand knowledge of that relate to this dispute and you want me to consider them, now is the chance that you have to tell me about those.
This is the third time she's trying to tell you. You keep talking firsthand knowledge, this. That is a legal term. She wants to hear what you actually got to say about it. Basically saying, hold on, you saying firsthand knowledge? Go ahead, let me hear you out here. Just don't drop the ball. She threw you an alley-oop. You better dunk it.
Yes, Your Honor. I do have some facts that I know about that I would like to have on the record.
Go ahead.
Okay. The four basic elements of a contract: the existence of a contract, any consideration given by the plaintiff, that the debtor, not the surety, breached an obligation, that the plaintiff suffered financial damages under the full accounting, refused to provide evidence of the original contract, along with refusing to provide the full accounting is concealment of the material facts of this case.
Okay, I'm going to back you up a bit. What you're doing is making an argument, which you get to do. That's a little bit down the proceeding. What I need now are the facts that would support this argument.
What did I tell you? I keep saying the same thing. All of your social media assertions and theories has to be supported by fact or the law. Just because you say the law says this doesn't necessarily mean the law says what you think it says. This is where proper interpretation of the law comes into play. But all of your assertions has to be backed by factual, it's called factual allegations, meaning allegations that are backed by black and white facts. Meaning, hey, I have a secret trust fund and I'm entitled to it, and the government never released those credits for me. You at the point in 1933, public statute 12534, all American citizens born or here now in the future will have secret private trust funds in their names, and they can draw on these trust funds to pay their debts or make purchases. The government shall withdraw the credits upon evidence of a legitimate debt or legitimate purchases that each American citizen wants to make. See, that will be a factual allegations to back up these secret treasury trust fund theories. The problem is you'll never find it. So you just got to find some statutes so you can throw a theory in there and make the statute says what it really didn't. That's a factual allegation. Hey, they disclosed, they said the finance charge under TILA will be the true cost of credit. Come to find out, Your Honor, my finance charge consists of A, B, C, D, E, F, G. None of what the finance charge, what they're charging me, has anything to do with the extension of credit, nor was it disclosed on TILAs in the itemization. See, they broke all this down on the itemization, but they actually hid the real cost of financing and what I'm actually paying and where my money's going to, because the itemization omits these 7 different things of which I'm really paying on finance charge. See the contract as exhibit. Hey, it's not me saying it. This is what they said. See their own words over there. That's called factual allegations to back up your claims.
You're rocking with the best.
I have not received these 4 elements that I've requested, Your Honor. That is a fact.
Anything else you want me to consider?
She said, you know what she said? Man, I threw you an alley-oop. You disappointed me. I thought you had something legitimate.
Your Honor.
Right. Do you wish to cross-examine Mr. Adams? That
No,
came
Your
out
Honor.
funny. I need a comma somewhere. Mr. Adams, would you like to cross-examine Mr. Dietrich?
Yes, Your Honor. Mr.
Go ahead.
Dietrich, I have heard you a couple of times mention being a surety. Can you please explain that a little more?
Hell of a question. Hell of a question. Now explain your theories in open court.
Yeah, so as signing as a surety beneficiary on the account, the all caps name is identified as a trust account.
What did I tell you? When you don't have factual allegations to back it up, you go back to your social media, patriot, sovereign citizen theories. But I tell you, they all do it. They all do it. Now, I'm glad that we're at this point, because now we can actually see how this stuff plays out in court. See, it sounds good online. It sounds very inspiring online. But all caps and this is in open court. Now you're going to see what they don't show you on social media. What happens when you actually go to court with this?
A trust account for. Can you please continue to elaborate? When you say it's a trust account, are you saying that this is not your account?
I am the beneficiary of this account.
Hey, in simple trust law, who pays the debts of the trust? The trustee, right? Doesn't the trustee pay the debts of the trust? Or that, under the agreements with the grantor? All the debts of the trust, don't the trustee has to pay the debts of the trust through the trust assets? I mean, it's simple trust law 101. The assets and the incomes from the trustee uses that to pay the debts of the trust. So all goes back to many people in America today who has actual trust. They don't have trust just to put property in it, just to stop a foreclosure or repossession. They actually put assets in a trust to keep it bankruptcy remote and to transfer the rights to receive payments from the collateral, which is generated income, over to a third party as an extra shield and protection. And they also get a structure in a way so they pay minimal taxes, because trusts are taxed at 37%. I know in these spaces, they tell you, oh, give the IRS its cut. The IRS is your friend. The IRS is not your friend. They're not my friend. And they are an 800-pound gorilla that you don't ever want sitting on your chest. Their job is to administer the tax laws and transfer wealth. That's it. All this Vincent Edwards, let's go, the IRS is your friend, give them their cut. No. Trust has, nobody has a trust that I know in which the assets that are already inside the trust are not producing income, cash flow, receivables. If you don't have at least $2 million in generating income, cash flow, you don't need a trust.
Mr. Dietrich, is your name on the credit card statements? I refer to specifically Exhibit 7 and Exhibit 3. Is your name and address on there?
There is a name and address on there.
And they're not your name and address.
Have you been able to verify and validate these names and address?
See, this is the problem. What I mean, these spaces will have you playing stupid on purpose. Diedrich knows it's his credit card account. Everybody in this space knows they got the mortgage, they got the auto. They know these things already. But for the sole purpose of getting out of their obligation to pay, why do you think many people run to these theories that are associated with sovereign citizens? It's not like they actually want to be one. It's because that's the only space that tells you you don't have to pay the debt. So you got people who already don't want to pay the bill or looking for a way not to pay the bill. That's why they flock to those sectors and all variations of it. Because before the contesting the debt, the person already told themselves that they don't want to pay this bill anymore. This is when they start looking for ways to justify not paying. And this is where the patriot, sovereign, moral communities come into play. Why do you think so many people, although they reject the name, they got all the talking points, all the ideologies, their documents look the same, but they just don't like the stigma of the name, so they'll reject the name. Not knowing it's your talking points, it's your words, it's your response to being called a sovereign citizen that put you in that bucket. I already know. You can't be a sovereign and a citizen. There's no such thing. It's an oxymoron. We know. They start telling people, sovereign citizens started telling other sovereign citizens to say one of those three responses when they started getting pushback from the courts and the public officials.
When you say verify and validate, what do you mean?
According to the rules of verification and validating debt.
The rules for verification value. So he means the statute. Okay. Nobody understands what he's talking
Can you
about.
please elaborate?
No, he can't elaborate because he's been reading from a script. He got this script for court. He got his script from his patriot community. All they told him was to say these few things, and the case is going to get dismissed, and he's finding out the hard way. With this Kenneth G suits, you get 3 suits for $99.99. Coming to court like that's going to change something. It doesn't.
Again, I am the surety and beneficiary subrogee of this account.
Yeah, how many times have you heard throughout these space, I'm the beneficiary, the subrogee, the surety, the beneficiary, you ain't the beneficiary of shit. Let's just you're not the beneficiary of nothing. You are not a named beneficiary on any trust documents. There's no millions of dollars in assets that's being passed on to you when the grantor passes. You ain't got shit.
So you were saying that your name is not Adam Dietrich.
I'm saying my name is also like that. I am not the all uppercase name That is
You see, as a grown ass man, a grown ass adult, you see how this space reduces your logic. See how it just see how it makes complete fools out of people. He's just making a complete fool out of himself right now. Embarrassing.
presented on your exhibits.
What if they said, hey, you just won $1 million check, and you go pick up the check, and your check is, your name is in all caps on the check. You think they're going to turn around and say, nah, I need my name in all upper and lower cases? Nope.
No more questions, Your Honor.
Thank you.
Mr. Dietrich, you have the opportunity to present what we would call redirect. You don't have to ask yourself questions, but if there's anything, any factual statements you'd like to make in response to Mr. Adams' questions, you have the opportunity to do that right now.
Don't worry, I got you. Your Honor, it's the new coach of Empire on behalf of Mr. Dietrich. Can we get an adjournment of this hearing to see if we could possibly reach an agreement with the plaintiff in this case? I just want to, speak to him, or if we can go into a breakout room for a second. Hey man, get your dumb ass in here. Listen, man, you got 30,000. You swipe the card. You got to do it. So this is what you do. Let me snap you out of reality. Get on a payment plan, and we're going to see if we meet certain thresholds that they'll actually keep your line of credit open. Bro, you got access to 30,000. You could be taking that 30,000 and turning that into 100,000 for yourself, using the proceeds of income that's coming from your initial investment of the 30 to pay back the debt, and you make some money. You're not making money this way. So take that 30,000 and put it in something useful that's going to generate income for you. That's going to generate income for you. Stop playing around. Play the corporate finance game. You already got 30,000. God damn it, Mom. You already got the 30,000. Don't fuck around. You can get it up to 100,000. Keep your face good with these people. You get up to 100,000, 250,000. Come on, man. Play the long game. You just worry about this short, immediate. Get back on track with these people and keep the relationship open. You playing. That's what I told him.
No, Your Honor.
Okay. Then at this case, I'll entertain both of your respective arguments. Mr. Adams, as plaintiff's counsel, you get to go first. Please proceed.
Thank you. U.S. Bank has shown that there are valid contracts that exist between the plaintiff, U.S. Bank National Association, and
Yes.
I'm sorry, am I still
You're
audible?
We hear you, yes. Can you
I'm
still
sorry,
hear us?
yes.
Okay, it's fine.
As I was saying, U.S. Bank National Association did have a contractual relationship with the defendant, and as evidenced by Exhibits 1 and Exhibits 5, the credit agreements. Mr. Gifford has testified to the fact that
Sorry, TikTok. That was my mom, Dukes. When she called back to back, that's my cue of nigga, stop what you doing there.
Relationship with the defendant, and
I'm gonna rewind it back a little bit for TikTok, YouTube.
Bank National Association.
Hold on.
Good to go first. Please proceed.
All right, there we go.
Thank you. U.S. Bank has shown that there are valid contracts that exist between the plaintiff, U.S. Bank National Association, and I'm sorry, am I still audible?
We hear you, yes. Can you still
I'm sorry,
hear us?
yes.
Okay, it's fine.
As I was saying, U.S. Bank National Association did have a contractual relationship with the defendant, and as evidenced by Exhibits 1 and Exhibits 5, the credit agreements. Mr. Gifford has testified to the fact that use was acceptance of the agreements, making a valid contract.
You dragging your S's just a little bit too much for me. I've been letting it ride the last 20 times you did it. Tighten up.
You have the offer, the acceptance be a use, and the consideration is that
He said the acceptance and the considerations of the uses of which Mr. Adams has got the contract, and plainly judge the specifics of the accounts, and he owes the debts.
Mr. Dietrich had the opportunity to use the credit accounts provided by U.S. Bank National Association, and U.S. Bank National Association provided the credit cards that enabled use of the credit accounts. Additionally, Mr. Gifford has testified to the fact and shown based on the exhibits entered, exhibits 5 and 8, that Mr. Dietrich defaulted on the contracts by failing to make payments when they were due. And as in default, the full balance is due and owing. And Mr. Dietrich has damaged the plaintiff for the amount owed, which is a total of $30,002.94 with both accounts.
The problem, this is where the corporate finance lens comes in at. This is exactly where it comes in at. Number one, you've already taken out insurance in case of default. You've already used CDSs. You've already recovered from the insurance proceeds. You've already recovered because you already have to set aside a certain amount just because of projected default. So when the default and when the forecast of the collections has reached at least 200% or less than the value that you expect to collect within the next year on it, you've already written off. So when you write it off, you're already getting all these returns and proceeds. Did you actually apply any of that to the actual deficiency amount before you have asserted a deficiency balance in court because your own policies say that you have to? And since you didn't do it, Your Honor, we have a serious issues of material fact because they may be asserting balances that they haven't reconciled under their own policies. Stop playing with us.
You're rocking with the best.
That is still owed to the plaintiff. That is what is damaged. And based on the breach of contract, the plaintiff is judgment, or the plaintiff may receive judgment.
And as soon everything I told you, I've been there, done that, already did it. Been there, done that. Ain't no theory. You're rarely gonna ever hear me speak theories over here in which I can't prove. Now, TikTok can't see this. Westlake tried the same thing. I told him to leave me alone. I was dealing with credit acceptance at the time. It was a voluntary surrender. I gave him the vehicle back because I got another one. I didn't need 3. 2 is good enough for me. I said, leave me alone. And you're lucky that you've already disposed of it because I'd have had another title. And everything I did everything I just said. And what happens when it got to court? During the trial, I was prepared. Non-suit. Your Honor, it's going to be a non-suit. Just dropped it. Went away. Never came back. Removed the thing from my trade line. Don't play with me. When I say leave me alone, leave me alone.
Thank you.
Thank you. Mr. Dietrich, do you wish to respond?
Once again, they're never going to present the balance to the court from the corporate finance lens, which actually is the true measurement of the indebtedness. They're going to wipe a lot of that stuff off, cash out on the back end, which significantly reduces the balance. But they're going to come to court with that same balance on top of the default. So all those proceeds, all those this, all those that's, everything they're getting on the back end in the default, what they're going to do, they're going to bill it right back to you, slide it right up in there, which inflates the balance, which they have no legal justification because the contract and the agreement in which they're doing on is never authorized on the note or the retail installment contract you sign because it's a private agreement that they have. I was able to see one. I was able to get one. I didn't find it on my own. because they don't file them publicly. But I was able to get one because someone knows someone that worked on the inside. So all those fees and all those stuff that they charging you when they bring you to court foreclosure, it's not from your note or your contract. It's from a separate agreement. This is why those damages are initially unrecoverable unless it's a foreclosure or through liquidation of the property. So they are not foreclosing. They're not bringing you to court because you didn't pay like he said. They're bringing you to court because they can double up. Everybody's already been paid on the back end. That default did not hurt the investors. They're already paid. Everything's good. Accounts been closed. Everything. When they report their balance sheets for the quarter and you add up all the accounts within that pool and you do all the calculations and the corporate industry standards for the interest rates, and I break down all the numbers are going to be minus his debt. I'm going to have a number, but when I add his debt to it, it's going to push the numbers up to where it should be. But I'm going to look at what they presented on their financial statements of position. It's going to be less minus his debt. And they do these things by the millions. So they think just because you see millions on the balance sheet that you're not going to take the time and break down the numbers in between those millions and millions of dollars. Not me. I will break $1 billion down to the penny.
Your Honor, I asked this case to be dismissed with prejudice as the plaintiff under the intent of FRCP Rule 12b-6. The plaintiff has not stated a claim on which it can be granted.
No, that motion is usually done in writing. You're not at. That's not what you really want in that moment.
Plaintiff has refused to produce evidence of the 4 basic elements of contract, which I spoke to earlier, the existence of the contract. The four
basic elements of the contract. That's that social media crap. That's that patriot community sovereign citizen stuff. Why don't you speak on elements as what the court rules, procedures, and substantive law says, not what you learned online? That's your problem. You're online learning from people who can't tell shit from apple butter.
Any consideration given by the plaintiff that the debtor, not the surety, has breached an obligation, that the plaintiff suffered financial damages under full accounting?
What does that mean? Suffered financial damages under full accounting. But this is not, many people online do this. When they don't really understand the legal technical terms of what they're talking about, they fill in the blanks with these vague words, these vague meanings, because they can only go as far as their understanding takes them. This is why I'm a fan of anybody that's getting into this stuff. You should not be sending one paperwork, one document, no nothing off, at least until you're in year 3, going on year 4. You need to do a 3-year, just sit back, hit the book, study. If you are sharp and intuitive, it can pick up fast, at least probably in 2.5. But there should be nobody that's new in this space that should be filing their own complaint suits within their first 6 months of being in this space. You have so much to learn about court. And normally you can only learn about the court experience unless you're inside of a courtroom. So you have to take your bruises, your bumps, and your L's in court before you come out and start winning way more than you lose. The problem is people's first introductions, they got their property and major stakes that's on the line. So you have to learn through the loss of your most valuable assets. It's the harsh reality that I don't see a lot of people willing to talk about.
There's concealment of the material facts in this case. Concealment is fraud. I'm not an attorney, but fraud vitiates all contracts. Therefore,
you're going to have Maxim's crap.
I demand this to be dismissed with prejudice.
Thank you. So you've referenced Federal Rule of Civil Procedure 12b-6. we don't follow the federal rules. This is state court, but Colorado does have a similar 12B5.
There you go. There you go. All my federal, where's all my federal people at? Federal law trumps state law. Federal law. All you got to do is go to state court and cite federal law. Federal law. Federal law. Federal law. Huh? Huh? Where you at now? I've been saying the same. Where you at now? Thinking you could go to state court and cite federal law because federal just trumps state law. So now when I talk about the 10th Amendment, hold on, he might know what he's talking about. When I say, oh, they got under the 10th Amendment in their state constitution, they can do this. Oh, federal courts cannot just unilaterally just go overturn and think you could just cite federal law. You're in the wrong jurisdiction. You're in the state court. State courts are governed by their state rules, their state procedures, their state statutes, unless there is a concurrent jurisdiction. And she just said it. Every judge is going to say the same thing I'm saying. But nah, go ahead. Continue to go to court and start raising federal statutes in state court. That's what y'all do. Just continue to do that.
Which would be motion for failure to state a cause of action that is typically addressed earlier in the proceedings.
Told you. He's at the wrong time. You're supposed to been do it.
What you're really asking me to decide is whether or not the plaintiff has proved his cause of action for breach of contract. And so I will address that accordingly. As you have reflected, the elements that are necessary for a breach of contract are that there was a meeting of the minds between two parties, that meeting of the minds set forth certain agreements that the parties agreed on, that one party received the benefit of that bargain and that the other party was damaged for one side not having complied with the benefit of that bargain. So we have to have an agreement. We have to have terms and conditions of that agreement that are sufficient to establish what the agreement was.
And I'm looking where I'm at. I'm looking at the accounting standards right now for that. You know, I live in the accounting rules. I'm looking at the accounting standards right now for it. That's exactly. I'm looking at the accounting standards right now. Yes, right now.
That a person of ordinary prudence could establish. Then we have to have a breach of the agreement. We have to have actual damages for there to be a claim for breach of contract. The evidence before this court establishes that there were two credit cards opened, a Platinum Visa credit card on a U.S. bank account and a Harley, exactly what that one was called.
Get it together.
A Harley Davidson Visa Rewards card also opened on U.S. Bank. These statements.
So do you see how he's smiling? You two looking goofy, smiling. He knew he opened the account. And this where it goes. Listen, y'all. This is why I don't buy this pro se victim. They're just out to get us. A lot. The ones who scream this victim, they're just out to get me. These are the ones who are the most disingenuous. Oh, the judge committed fraud. They committed. No. You knew what you was doing from the beginning. You just don't want to pay your damn bills. Just say that. I don't want to pay my bills. And I need to look for a way to justify not paying it so I won't get in trouble and still be able to keep the asset or keep the benefit and use of it. You want all the benefits and use of it, but you don't want to handle your financial responsibilities to keep it. You want a house for free. You want a car for free. You want money from the government for free. When are you ever going to just say, I'm going to go out here and get it on my own? Why do y'all want so much free stuff? Is it that bad? Are you that like you have no in your everyday, like there's nothing there with you that wants you to go get it? You're that ineffective in real life where you think everything's supposed to just be given to you for free and you don't have to have no responsibility for it? You think the world works like that? Everybody that follows the ideologies, you are saying, I'm an ineffective individual. I don't have the capabilities. I'm a non-factor in the world. That's what you're telling yourself. No, these people looking for a shortcut to successes. You got to earn it. Ain't nothing given to you.
In those, the statements for those accounts reflect that items were purchased.
There you go, right there. So you trying to say you never swiped the card? Identity theft? Look, he swiped the card. What did I tell you forever? I've been telling you that forever. What is the judge court's going to look at? I said in the beginning, they're going to look at the contract, the debt, if he swiped, who made payments on. Why do you think the judge brought up you swiped the card? Because he know he did. Oh, I'm the beneficiary and the surety. Man, get that crap out of here.
The testimony of Mr. Gifford establishes that U.S. Bank paid money to third parties for those items. Mr. Dietrich has conceded that he is the beneficiary of these cards.
Use his own words against him.
Thus, the court can make a sufficient inference that he received the goods that were paid for, as reflected in the statements that
don't even understand when he was using the term beneficiary. Basically, when they use the beneficiary, means, oh no, I'm just the beneficiary. It's the all caps. That's not me. The all caps got to pay you, not me. I don't got to pay you nothing. The all caps got to pay you. Okay, let's accept your premise. Show us how the all caps can go get the money. I don't know. That's just what I heard online.
Bear the name Adam Dietrich. Admittedly, the name Adam Dietrich is typed in all caps on these statements. Mr. Dietrich takes issue with whether or not that is indeed him, as opposed to him in some form of trust. There has been no evidence presented to this court that there was a lawful and valid trust established under the laws of the state of Colorado.
See how they spanking all your social media arguments with real life law and reality? Told you. All this shit that you hear online, they can never prove it in court. They can never prove it. I told you, it sounds good online. It's just one big kumbaya, my lord, kumbaya. Everybody holding hands in a circle in the virtual panel, holding hands virtually, and everybody just telling each other how good it's going to be. I deal with reality of life. That's the problem. I just wanted to hear from people who's going to tell you what you want to hear and make it sound so nice and talk to you like this in a calm and meek term. Right.
That would have opened and held this credit card and that would have been responsible for the payment of this credit card. The evidence before me is laws of the state of Colorado, as opposed to him in some form of trust. There has been no evidence presented to this court that there was a lawful and valid trust established under the laws of the state of Colorado that would have opened and held this credit card and that would have been responsible for the payment of this credit card. The evidence before me is that Mr. Dietrich, as the admitted beneficiary of the goods of these accounts, has received the goods, did
you notice how she took his social media sovereign citizen theories and claims and applied it up against with the law. Just notice how he wasn't even thinking that far down the road. That you are listening to the legal lens, how the court sees it. The court sees it as she said. He sees it as something else as a consumer. The witness sees it as something else as just dealing with the accounts and the records. The lawyer sees it as non-payment. Hey, we can collect. So even in its own setting here, the 5 lenses of the contract influence is present. I have spearheaded a new generation of consumer arguments with the creation of the Supreme Elite Team University and the 5 lenses of the contract. Nobody has ever done that before me. I'm the first one to ever do it. Want to know why? Because I built it for 3 years. I built the university 3 years from the ground. That's why you can't find no templates in my university. You can't find things from what other people taught before in my university. It's all built from scratch. Truth seeker, am I lying?
They studying the source now. Supreme Elite. New Empire Talk.
Have knowledge of the accounts, did use the accounts. The information contained in the card agreement says that use of the accounts is acceptance of the agreement for the account. That's what created the valid and binding contract.
Uh-oh. Valid and binding contract, aka enforceable law.
Mr. Dietrich raises concern with whether or not a sufficient accounting has been presented to him on these credit card accounts. The statements themselves are the accounting that the statement agreements agreed would be accepted as the accounting.
And this is why the Supreme Elite Team University is so powerful, because we break beyond the normal statements and actually get to the substance that would invalidate even what they're saying. The statements will actually be our evidence against them.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume, war stories in the fine lines.
It doesn't have to be set forth in a 2-column ledger type of system that Mr. Dietrich was inquiring about, because that's not what the card agreement's called for. The agreement between the parties indicates that the statements would be the accounting for the account. This is not a circumstance where someone else opened the account.
What did I say? That's the only way you could do this. Wet ink signature. That's what I say. Identity theft. I said it 30 minutes. Come on, y'all. Y'all know I said it 30 minutes ago. Oh, almost. Y'all know what I'm saying. Hey, somebody open up the account with my name. Oh, you'll be able to prove that because you know where you're at. You know what I'm saying? You got witnesses. You know what you was doing in that moment. What did I say? The only way this wet ink signature stuff works and all that other stuff works is basically you're saying somebody else opened the account in my name.
You're rocking with the best.
And the judge came right back around and said the same thing.
Chance where someone else opened the account and Mr. Dietrich didn't have any knowledge about it at all. And so
what did I say? She said, the judges, if you don't want to hear from me, my classic line, if you don't want to hear it from me, I will let the judge tell you.
someone else used the card in Mr. Dietrich's name, and he didn't get the benefit of the purchases. No evidence to that effect was presented to the court. That might create a different result, but there was certainly no evidence that Mr. Dietrich did not receive the benefit of these accounts. And on cross-examination, he confessed that he is indeed the beneficiary of these accounts. And so I am going to find that there was an agreement made on both accounts between Mr. Gifford and certainly for the benefit of Mr. Dietrich, that charges were made on the accounts, that U.S. Bank paid for the items that were made as a result of the charges on the account, and that it's reasonable for the court to infer that Mr. Dietrich did receive those goods.
I would have spanked them on the interest. I would have spanked them on the, well, I gotta leave that part out because that's set you knowledge. But credit cards is that's even a tricky one. Oh, that's even a little different one right there, because they do something different that they don't do with mortgages and autos with credit cards. So I would have spanked them on that. I would have spanked them on the reconciliation. I would have spanked them on their own agreements. I would have spanked them on their internal assumptions and their internal accounting and their internal modeling. I would have used their own admissions against them, and I would have wore that $30,000 out. I would have wore it out. But when you're dealing with social media gurus, this is the passed down recycle information that you get. If you don't want to learn the game from multiple lenses, see the game from how multiple lenses, multiple agencies see it, the corporate finance side, that's the accounting, that's the reporting, that's how the lenders see how things went down, that's how they look at it, that's their pricing, that deals with how they even structured the numbers on your contract, the source of those numbers, how they derive to those numbers, the calculations for the APR, the calculations for the finance charge, which you're actually paying. Why do you have to pay a down payment? What's the legal reason why? Or what's the reason why they say you got to pay a down payment? Why are they taking a haircut off your loan proceeds? What's all these measurements and things that they do? How do they look at these contracts? Then you got the regulatory, that's the authoritative guidance. Then you got the regulatory, that's the authoritative guidance. That's the all the regulatory agencies and all that stuff. Bam. Then you got the investor lens. You got the disclosures. How did they see the contract? Then you got the court and legal lens. How's the court looking at it? And then add all that together. That's when you get to your consumer lens.
You're rocking with the best.
And your consumer lens, although it's bringing consumer claims, your consumer claims will actually read like class action lawsuits.
You're rocking with the best.
Basically, you're going into their system, drawing their system out, hooking up to your claims. Now defend against your own words, defend against your own functions, defend against how you operate. The mere fact that they do what they do, it's already a violation. That's why it's not just us against them. We are attacking the system. Most definitely using his words against them. Of course. Oh yeah, they're sophisticated. They're sophisticated.
Thus, and that he has not paid these statements as is reflected by the evidence before the court. And thus, U.S. Bank has satisfied its burden of proving by a preponderance of the evidence that Mr. Dietrich is responsible for the amounts due on these accounts, and the court will order that Mr. Dietrich is required to pay the balances of the accounts, which specifically as to the Harley Davidson account was $13,809.96. And specifically as to the Platinum Visa account was $16,192.98.
Now mess this credit up. You really thought, and this is the, okay, so right here, for every time you see someone post online about a Midland credit card win or a Capital Resurgence credit card win, like a successful client, it's 5,000 of these outcomes. 5,000 of these outcomes. Millions of judgments like this are taking place a week across America in court. So no, I know we feel like we're doing something because we get a little win here or there, but in reality, the success rate is still less than 2%. The average pro se litigant is going to lose their case. As a matter of fact, pro se litigants lose their cases at an alarming rate at 97%. And it's not hard to see. Just look around social media. For every one win that you see, 1,000 of them has lost. It's the reality.
Mr. Adams, do you have any further requests of this court?
No, Your Honor.
Mr. Dietrich, do you have any further requests of this court?
No, Your Honor. Thank you.
He ain't mad at the outcome. He is not mad. Wanna know why he ain't mad? He ain't mad. Because he know what's going on.
Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary.
Already. You see where this about to go. More beneficiary. We just heard the last one that used a beneficiary. Here we go again. I told y'all, this is 98% of what's in these spaces. Sadly enough, people like me, we represent the less than 0.1% of these spaces. In Supreme Elite Team University, it represents 0.00001 of these spaces. It's just the reality.
I'm here in my proper person.
What's your first name?
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and having reached the age of majority.
Look, got all the buzzwords.
I'm a Moore Aboriginal, America's Aboriginal, Illinois National.
Is
but
Kimberly
not a citizen of the original, right? And I've had the age of majority. I'm a Moore Aboriginal, America's Aboriginal, Illinois National. I'm a Moore Aboriginal, America's Aboriginal, Illinois National. I'm a Moore Aboriginal, America's Aboriginal, Illinois National.
Is
but
Kimberly
not a citizen of the United States.
Not a citizen of the United States. He don't even realize he got that from the Patriot community. Not a citizen of the United States. Look at him. Look at him just spitting in the face of Dred Scott and all the slaves and all the people who fought with their lives to get the freedoms and the protections under the U.S. Constitution. And the first thing you want to say is, I'm not a U.S. citizen, when the 14th Amendment was actually passed for African Americans. Because when you look at the year, everybody wants to tie the 14th Amendment back to 1933. Matter of fact, before we get there, let's do a little history search. When was the 14th Amendment passed? The 14th Amendment was passed in June 13th, 1866, and officially ratified by the states on July 9th, 1968. The landmark Reconstruction Amendment established birthright citizenship, meaning you were a United States citizen if you were born in this country, and guarantee equal protection under the law for all citizens, specifically protecting formerly enslaved people. What did I say? The 14th Amendment was passed for African Americans. That's why they passed it. Oh no, new coach, you don't do your historic research on these topics of these things. Nah. All right, Truth Seeker. And negotiate to keep that 30,000 credit card. You're damn right I would have. Yeah, U.S. Senate historical records, or view the original text in the National Archives. You can go down to the National Museum in D.C. and read the original 14 minutes. They got it in a big glass screen. And in that, it talks about, you're going to see the whole thing. The 14th Amendment was passed for African Americans. Watch this. Was the 14th Amendment really passed for African Americans and as a response to the Dred Scott case in substance? Because I know it applies to everybody today who's born in America. Was the 14th Amendment really passed for African Americans and as a response to the Dred Scott case? Yes. In substance, the 14th Amendment was passed explicitly for African Americans and as a direct literal response to the 1857 Dred Scott versus Sanford Supreme Court decision. Yes, the 14th Amendment was passed explicitly for African Americans and as a direct literal response to the 1857 Dred Scott Sanford Supreme Court decision. See, when you do your historic research instead of that revisionist history research, you'll actually come to a more accurate conclusion versus the revisionist history. When I ask everybody, what year was the 14th Amendment passed? I've seen these patriot movements, white supremacist movements, where they say the 14th Amendment was passed in 1933. A lot of you thought it was passed in 1933. Oh, that's when they made us debt slaves. 14th Amendment. Who told that story? Who told that story? That story ain't come from African Americans, because no African American historian or historians general, regardless of race, would have ever said that. Anytime there's something that was directly for us, they always want to change the history. Now you got African Americans running around. 1933, we became debt slaves to the government. How you become debt slaves to the government in 1933 when it was passed in 1867? But nobody wants to talk. Talk now. Talk. Talk about your 14th Amendment now. Talk about it now. Don't remain silent. Talk about it now. 14th Amendment, 1930. Talk about it now. So I'm saying. Always get silent when the reality comes out. So I love silence. In the Dred Scott decision, Chief Justice Roger Taney ruled that Black people, whether enslaved or free, were not and could never become citizens of the United States, famously claiming that they had no rights which the white man was bound to respect. To completely erase this legal precedent, the framers of the 14th Amendment engineer the citizenship clause as the very first sentence of Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states where they reside. That doesn't mean whether you consent to it or not. That's not, well, if I want to be, if your plane had to land and it was in a country where war was breaking out, and you got the U.S. Embassy right there, or you got the Moroccan Embassy right there, or you got all these other embassies, are you non-U.S. citizens, you're bringing your ass to the U.S. citizens embassy. You know you are. When it gets real, you a U.S. citizen. What if they start rounding all y'all up? Hold on. You said you wasn't a U.S. citizen. What you do in this country? Where your paperwork at? You're going to pull out your birth certificate and your social security card fast and be like, no, I'm a U.S. citizen. When they want to uproot you for your family, you're going to be a U.S. citizen then. That's what I'm saying. Y'all just talk it when it sounds good, but y'all never stand on it in the face of intense pressure. You never, I've been around this space long enough for years. None of them ever stands on it. By establishing birthright citizenship, Congress legally nullified Taney's ruling, ensuring that the 4 million newly emancipated African Americans were automatically recognized as full federal and state citizens. National Museum of African Americans. Link. Striking down Southern Black codes. While the 13th Amendment abolished slavery, former Confederate states immediately enacted restrictive Black codes. These laws legally prohibited African Americans from owning property, voting, suing in court, or moving freely. The ACLU of Arizona is the source of that statement. The remaining clauses of Section 1 were tailored in substance to neutralize these racially discriminatory state laws. Privilege and Immunities Clause. It prevented states from denying African Americans the basic constitutional rights tied to national citizenship. National Civil War Museum. Due Process Clause prohibited states from arbitrarily stripping Black citizens of life, liberty, or property without fair legal proceedings. National Civil War Museum link. Equal Protection Clause required states to provide the same legal protections to Black Americans as they did to white Americans. National Civil War Museum. Historical records and debates from the National Museum of African American History, if you ever been there like me. And culture, and the ACLU showed that the authors of the amendment, known as radical Republicans, intended to create a constitutionally protected floor of racial justice and equality. Yes, the Republicans came together for that one. While the phrasing was written broadly, all purpose to encompass future generations of immigrants, its immediate substance and historical catalysts were unequivocally centered on securing the legal humanity of African Americans. So when I say the 14th Amendment was actually written for African Americans, that's what the fuck I mean.
You're rocking with the best.
Why does the 14th Amendment and all national historic links, and I've been to the National Museum of African American History and Culture, so this ain't lying because I've already been there. You want to know why? Because I did a book report on it in 10th grade in high school during Black History Month. That was my assignment, to do a book report on the 14th Amendment. The teacher asked me to do it. And my mom helped me. And I gave a whole class presentation with the pictures on the posters. Yep. So I want to hear about this 14th Amendment 1933 shit. Why does the 14th Amendment seem to be tied to 1933? The 14th Amendment is strongly tied to massive constitutional crisis over the U.S. financial system, triggered when President Franklin Roosevelt and Congress abrogated the Code Clause in public and private contracts to combat the Great Depression. This move directly collided with Sections 4 of the 14th Amendment, sparking a legal battle that literally broke the power of the Supreme Court. Oh, I see what they did. So, in Section 4, the validity of the United States debt authorized by law should not be questioned. So they added Section 4. Hold on. They added Section 4. They added Section 4 of the 14th Amendment. Oh, no, here we go. No. Prior to 1933, most U.S. Treasury bonds and private contracts contained a standard gold clause, guaranteeing that creditors will be paid back in gold coin or its equivalent valuation. On June 5th, 1933, shout out to my B-Day, trying to halt deflation and massive bank failures, Congress passed a joint resolution declaring all gold clauses void, null and void. The government took the U.S. off the gold standard, ordered citizens to turn into their gold, and devalued the dollar. Suddenly, investors who were promised repayment in high-value gold were being paid back in heavily devalued paper currency. Bondholders sued the government, arguing that the 1933 law violated Section 4 of the 14th Amendment. Section 4, originally designed to ensure the Union's Civil War debts will always be honored, explicitly state the validity of the public debt of the United States authorized by law shall not be questioned. Library of Congress. The creditors argued that by wiping out the gold clauses and paying back less value than promised, the government was illegally questioning and repudiating its own public debt. The resultant legal battle culminated in a series of landmark cases known as the Gold Clause cases. Have any of you social media 14 read the Gold Clause cases that took place all around 1933 and 1935 when there was 1,000,001 case laws going out? Y'all read the Gold Clause cases dating back to 1935? No, because they never do their historic research before they start believing in these ideologies. The Supreme Court actually agreed that the 1933 joint resolution was unconstitutional. Chief Justice Charles Evans Hughes ruled that Congress had exceeded its authority and violated the 14th Amendment by breaking its own contractual promises. However, in a bizarre twist, the court ruled that the plaintiff could not recover damages because devaluing the dollar had caused the no actual loss of buying power in the current economy. This face-saving maneuver averted a catastrophic financial crash and prevented Roosevelt from executing a drafted fireside chat in which he planned to openly defy the Supreme Court. So what does the 14th... I don't see nothing about the 14th Amendment talking about U.S. citizens being debt slaves. Man, have to do with making U.S. citizens slaves or collateral for the public debt. Legally and historically, I'm talking about historically, historians, the 14th Amendment has absolutely nothing to do with making U.S. citizens slaves or collateral for public debt. In fact, Section 4 of the amendment explicitly forbids the government from paying any debts related to the loss or emancipation of slaves. The idea that the 14th Amendment turned citizens into financial collateral is a completely fabricated pseudo-legal theory popularized by the sovereign citizen movement.
You're rocking with the best.
And you want to know why? Because I read the whole HJR 192, the congressional debate on the floor. I read every word, every Congress that spoke. I read the whole debate from June 5th, 1933, in which the law was passed at 4:33 in the afternoon. Damn, how you even know the day, the time? Think about 4:30 or 4:33 in the afternoon when it was passed. Because I read the resulting cases from the fallout of it. And I look for anything to point to the U.S. citizens being responsible for the national debt. And I spent years, didn't find not one word. So when I got a document that saying that we was, I noticed that they were quoting HJR 192, and I knowing what it actually said, and they were twisting HJR 192 around, which led me to believe that they was given a theory. And this is predominantly done by the white patriot movement. No black historian has ever came out and said that blacks were slaves to the government under the 14th Amendment. Financial. And this is the problem when you adopt the ideology and read documents without fact checking its source, without doing your own historical research. Many people who cite statutes in HJR 192, they don't ever go back and read what's actually saying. because someone already provided a sentence, and that's all that person needs. The mental laziness of people in these spaces is astonishing. The movement blends the 14th Amendment and the 1933 financial crisis into a conspiracy theory constructed from three core myths. One, the myth of the 14th Amendment citizenship. Sovereign citizens claims that there are two types of citizens, sovereign or de jure citizens, white Americans who allegedly derived their rights from God in the original Constitution. Told you. A lot of my African Americans, what's up, Steve? A lot of them are following ideologies from people that would have burnt you at the stake if they had the opportunity. And the 14th Amendment citizen, a separate class of corporate citizens created after the Civil War who have no constitutional rights and are instead slaves to the federal government. The reality, the 14th Amendment did not create a new lesser class of citizens. It did the exact opposite. It expanded full constitutional rights and birthright citizenship to African Americans who have been explicitly denied by them by the Dred Scott decision. National Archives. The myth of the 1933 corporate bankruptcy. The theory links 14th Amendment citizenships to 1933 by claiming that when President Roosevelt took us off the U.S. gold standard, the federal government went bankrupt. The conspiracy argues that because the government had no more gold to back its loans, it pledged its 14th Amendment citizens as collateral to international banks, selling our future earning capabilities to foreign investors. The reality, taking a currency off the gold standard is a monetary policy decision, not a declaration of corporate bankruptcy. The U.S. government has never declared bankruptcy, and human beings cannot be used as financial collateral under the law. And I know y'all read congressmen saying, the government is basically bankrupt. That doesn't mean it's law. That was his opinion on the state of affairs of the government at the time. That doesn't mean the government actually declared bankruptcy. It wasn't law. So y'all took words and thought that it was law, meaning you've been wrong the whole time. And evidence of you being wrong is whenever you submit documents reference to this crap, it goes nowhere. 3, the straw man and secret treasury accounts. According to this myth, when a child is born in the U.S., the government uses their birth certificates to create a secret corporate shell or straw man identity written in all capital letters on government documents. They claim the U.S. Treasury sets up a secret bank account linked to each birth certificate worth anywhere from $600,000 to millions of dollars, using citizens as collaterals. Lawrence Journal World, 3 other links. Followers of this movement uses redemption schemes attempted to file fraudulent tax documents or fake financial instruments to extract this secret money from the government to pay off mortgages, credit cards, and court fines. Institute of Strategic Dialogue. Now tell me this space today and a byproduct of these early ideologies. Tell me what you see today in these spaces, the Vincent Edwards of the world, the Tory Martins, the Honey V, all tell me they have not adopted these ideologies. But if you tell them that they represent a sovereign citizen, they're going to say, you can't be a sovereign and a citizen. There's no such thing. Hold on. There's no such thing as a sovereign and a citizen. You can't be a sovereign and a citizen. A sovereign citizen is an oxymoron. They're giving you the same sovereign citizen response, but swear they're not one. Federal courts and the Federal Bureau of Investigations and the IRS have repeatedly and universally rejected these claims as frivolous nonsense, attempting to use these sovereign citizen legal arguments or fake financial documents in court invariably results in heavy fines and prison time for tax evasion, wire fraud, or contempt of court. Has anyone went to prison or prosecuted for sending a fake check to the IRS and or receiving an erroneous refund from these fake checks? Yes, numerous of people have been prosecuted and sentenced to federal prison for sending fake checks, financial documents to the IRS, or illegally keeping erroneous refunds generated by sovereign citizen redemption schemes. I don't care if Vincent Edwards calls it the execution class. I don't care if these new age teachers are selling this stuff. They all got the ideologies from the original patriot sovereign citizen movement that took place in the early mid 1980s. The DOJ and IRS CID aggressively tracks down these exact offenses, treated them as felonies for mail fraud, wire fraud, conspiracy theory, and making false claims against the United States. And there's the link. Sovereign citizens going to prison. They got the links. All the people going to prison. Department of Justice in their news release. Christopher Eugene Guilford, sentenced to 4 years, 3 months in prison. A federal court sentenced Guilford for executing a sovereign citizen redemption scheme. He filed multiple false tax returns utilizing falsified financial forms to fabricate income and withholdings, attempting to extract a fraudulent refund of over $1.1 million from the government. Judy Grace Sellers, sentenced to 9 years in prison. A Florida sovereign citizen was handed a 9-year federal prison sentence for a $3.4 million tax fraud scheme. Her scam heavily relied on promoting fraudulent financial instruments, specifically altering IRS 1099 OID forms to report fake debts as income and demand massive government payouts.
You're rocking with the best.
Alice Marie Ryden, indicted on 4 felonies in 2026. In a recent case out of Kansas, an avowed sovereign citizen filed fake tax claims. The IRS actually erroneously issued her a check for more than $2 million. When she attempted to cash the erroneous refund at a credit union, suspicious employees blocked the transactions and alerted the government, resulting in her federal arrest and indictment for mail fraud. When you are not used to putting that money in your bank, you're used to putting $3,000, $2,000, $1,000, $1,500, $20, and then you pop up with a $400,000, $200,000. The bank is going to look at your income, your receivables history, the money that you got coming in, and they're going to flag it as fraud because you're not used to getting it. Where you get all this from? See, when you clear $15,000, $20,000 a month for 3-4 years, it's not surprising when you come with $100,000, $200,000 check because your bank like, oh, now you used to getting this money. The Hunt family scheme, multi-million-dollar sentences. A family network submitted fake documents, falsified financial instruments, and altered money orders, meaning scratching the money order out, the $1 money order, and writing the amount in to the IRS to claim over $8.5 million in fraudulent refunds. What did I tell you? The wicked evil spirits of these people in these spaces under the eyes of God and spiritual and the emperors and the emperor, all these lion tribe, ancient Egyptian avatars. These are the biggest fraudsters, scammers, and wicked, greedy spirit people. Anyone with these exalted Greek mythological gods names, Queen Empress of the Queens, and the King Emperor of the Trust Ministry, Trust Private, the scammers. The IRS mistakenly paid out over $1.7 million before catching the fraud. The co-conspirators were caught, prosecuted, and sentenced to federal prisons. Conspiracy theories often tell followers that if the IRS accidentally mails a refund check or deposits the money, it means the redemption worked and the money is legally theirs. This is completely false. When the IRS accidentally issues a refund check based on a fake document, the money is called back. The government freezes banks' accounts, seizes any assets purchased with the funds, such as homes and vehicles, and issues mandatory restitution orders, forcing the perpetrator to pay back every cent. Criminal intent is proven. Cashing, spending, or transferring an erroneous check that you triggered via a fake document is used by federal prosecutors as a definitive proof of intent to defraud, which virtually guarantees a prison sentence. The IRS maintains an explicit warning list regarding these frivolous tax arguments on the official IRS tax scams page, noting that utilizing fake checks or sovereign citizen arguments carries a standard penalty of $5,000 per filing, completely separate from criminal jail time. But they don't want to hear it from me because I'm not telling a desperate, greedy soul what they want to hear.
You're rocking with the best. You're rocking with the best.
Desperation and greed are two of the evil inner spirits that lies within 98% of people in these spaces. Desperation and greed, because a desperate person will throw bricks at the penitentiary for money. So when I say 98% of these people in these spaces will do anything for money, they will sell their soul for money. This is what I mean. They'll do anything for money. They have no moral compass, no moral grounds, no principles, no nothing. They will sell their souls for money. And that's 98% of these teachers online too. Anything for money. They will purposely sell you a fraudulent document if you're willing to pay $200 to them right now. Oh, yeah. Oh, yeah. Oh, yeah. Oh, yeah. 7 charged in sophisticated stolen identity tax refund fraud scheme. Sought over $100 million from the IRS. March 13, 2023. On March 7, a federal grand jury in Austin returned an indictment unsealed today, charging 7 individuals with conspiracy to commit mail fraud and wire fraud and other crimes arising out of their scheme to defraud the IRS using stolen identities. And the people who were in Vincent Edwards' group or took these classes and got a check that they know they wasn't entitled to legally, they would leave my life. Not because they don't want to hear it, because they gotta, once their soul starts to convict them, they'll leave anyone who's triggering that moment. And think just because if you don't hear it, you're still good. And they'll immediately go back to some document or some class that reinforces them. According to the indictment, from 18 through 21, Abraham Yusuf of Round Rock, Megan Inyang, Christopher Eduardo, Christian Matherin, Dylan, all them, engaged in a conspiracy to claim fraudulent tax refunds using the stolen identities of accountants and taxpayers by filing at least 371 false tax returns. They also say they obtained prepaid debit cards. Hold on. They allegedly directed the IRS to change the addresses on file for the taxpayers and to send their tax information, including account transcripts, wage records, to addresses controlled by the conspirators. They used this information to electronically file tax returns claiming fraudulent refunds and directed the refunds to the IRS to split the refunds among several prepaid debit cards. Prior to issuing tax refunds to some taxpayers, the IRS allegedly sent verification letters to the addresses controlled by the defendants, and the defendants and others pretending to be the taxpayers instructed the IRS to release the refunds. The indictment also charged all of them by obtaining prepaid debit cards that were used to receive the fraudulent refunds, and that once the refunds were deposited into the prepaid debit cards, they laundered these funds by purchasing, among other things, money orders from local stores in amounts low enough to avoid reporting thresholds. Yusuf and others allegedly used the prepaid debit cards and money orders to purchase designer clothes, home renovation materials, and used cars at auctions. What did I tell y'all 2 years ago? They never do anything that's going to bring them more money. They only do these things to be bigger consumers and bigger spenders, to have something to show online to say, I made it. They all buy symbols of wealth. They don't ever put that money into that generational wealth that they claim. It's desperate people, greedy people trying to live lives that they can't afford in their everyday lives. This is why when the government comes, they have nothing to show for it. Hey, government, yeah, I got this 1.5, but look, I created $1 billion. I created a $3.7 million business. I got business going. I hired employers. You know what? Pay us a fine. And the government would have went for that, because now you're creating jobs. You hired these employers. Now they getting taxed. The government said, you know what? You're going to pay a fine. We're going to leave it because we can collect money off you. Nah, pay a fine. Not with these people online. When they come, it's just a bunch of cars, clothes they season, trinkets, and symbols of wealth. Just to come online and be like, look, follow me. I got the shiny new toys that a bunch of people who can't afford it. And that's what they use. Shiny new toys. They use symbols of wealth to lure people into taking their classes. They're not showing a balance sheet. They're not showing portfolios. They're not showing receivables. They're not showing income producing assets that creates generational wealth for real. They're not showing acres of lands where they're building property on it. They're showing you symbols of wealth. It's no different from the multi-marketing level scheme shit that you see online. Hey, you want to make $3,000 in a day, or show posters on Instagram with stacks of money, wads of money? That's all they do. That's all they do. That's all they do. I don't show money all the time. I got a sack on me right now. Look. All big boy bills. All big boy bills. All big boy bills. All big boy. I gotta show it every 5 seconds. You get rich like me. Show me your money. Yeah, it's BS. It's BS. Can't stand these people. It's BS. Their intents ain't right. Their spirits ain't right. And this is why everybody that follows them crumbles. And this is why these people can't stand me. Because I'm speaking the things that their own souls are speaking to them every day. That's why they run when I come around. That's why they always got to respond to me in the comments. They always got to address me, because I see through them. Because when you're moving with a clean spirit, when you're moving in honesty, and you stand on principles and morals, and you're not breaking them for $1, they hate you. They can't stand you. Why aren't you being desperate like us? Why aren't you chasing a bag like us? I don't need to chase a bag. You don't have to chase a bag. Trust me. The money will find you. When you do good to people, when you pay your dues, when you do the right thing, even if it's the smallest thing, when no one's looking, you get your blessings in a way that no process could ever give you. And this is why I am the way I am. So if you want me to change my tone, change my talking points, tone it down just a little bit, nah. Until next time.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee into case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. From the first lay build to the full camp. New culture empire, watch the flag plan. Supreme Elite Team University. Turn the credit score into currency. Turn the closed door to a first key. Turn the side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. Wave it. From the first lay build to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. From the first lay build to the full camp. New culture empire, watch the flag plan. Run it up. I'm in the kitchen, cooking up something new, yeah. She's singing along to our favorite tune, wow. Enjoying the breeze from Toronto. They admire my watch at the show. You seem like you had something to share. What's up? I thought so. Okay. I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight. I'm feeling ready for the night. Confidence high, we making moments to remember. And leaving behind the worries, moving forward, favor. Got a plan but no rush, just taking it slower is better. Embracing the job with friend and enjoy. Right. My confidence never wavers when I'm focused. focused on the table. No time for negativity, let's lift up. This energy's electric, bringing us together. Feeling alive and fulfilled. Shawty saying that I am the one. Who does she think she's talking to? She wants someone who brings unity. After freshening up with a clean routine, the momentum's back, freak inspired and free.
No pressure, nah, I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit, I'ma let her. With this street code, I abide to the letter. It's just me against me, I ain't feeling no.
You're rocking with the best.
Damn, Clinton, you snapped on this one.
Pop a little crazy for this motherfucker.
Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We slip the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a block, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by that late 20X on the plate. A brick in the safe, the semis the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the fake. Off the ace out of spades, sit by that case, you ain't sliding for nothing, you'll still I'ma take. My bitch, she get it, she got it, she paid. Money talks, my bitch, she got it the same. The chopper still sound like a head-away base. They pay that they seeing great, they on their place. The face when they die, try to make them a case, and these bitches still biting, they taking the bait. She gag on this dick like a sock in her mouth, and these haters, this 40 not sparks on their face. Back on this land, I'm not giving this shit. Go straight to hell, send her my wish. I ain't gon' fuck her, she burner, she white to my girlfriend, that see she just get in the mist like a broke on that car. She was sitting on bricks, and they stop for attention, they slitting their wrists. She won't let me fuck this, my slip with some chips, I might step in her mouth, need to step in my dick. Sweat that guy, I want no problems, but solve it. Baller, selling this way that we chop it. Stop it, you don't have no stocks in your pocket. Drop it, that gun that you know you won't pop it. Pull up in the roads, you know you gon' watch it. The roadie $6, you know you gon' clap it. I get my bitch wet, make her drip like a faucet. They won't call like that, all my bitches are flawless. Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We slip the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a block, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by that late 20X on the plate. A brick in the safe, the semis the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the fake. Off the ace out of spades, sit by that case, you ain't sliding for nothing, you'll stick I'ma take. Ain't no cigarette, rich as a bitch, but all my niggas who get richer than this. In love with the yayo, I'm flicking my wrist. Back door with nigga, just switch off the pit. 40 your hand once assist off the hip. 40 more Benzes to flip off the brick. 20 more racks, that's the flip off the flipping. And flipping, his brain's gonna flip out his shit. No roof when I blow out the endo. I got plenty doors, I just spent for my Kindle. 200 I matched, no mistake for a rental. High off the molly, I eat out the middle. High off the molly, she suck to a spit up. High in my sleep, she gon' suck with the dick up. High in her sleep, I start off with a sister. High as can be, put his dick all up in her. I'm the general, these my gorillas are ace. Stop the shit out you, then you step by the lake. Be spoke with the Stradley, you step by the cake. Play with her, no, she won't step by the 8. Tell that bad bitch to come sit on my face. I got these racks and a hard dick on her plate. Are you rats eating cheese? I hope it is lakes. Claim that you ballin', I hope you can play. Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We slip the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a block, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by that late 20X on the plate. A brick in the safe, the semis the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the fake. Off the ace out of spades, sit by that case, you ain't sliding for nothing, you'll stick I'ma take.
You're rocking with the best. You're rocking with the best. You're rocking with the best.